Good morning. My name is Bob Nichols. We really appreciate all of you joining us. I'm with Bracewell in the firm's Houston office. Let me tell you a little bit about what I do and about our other speaker, and our other speaker being the more important of the two individuals for this topic today. I am a labor and employment lawyer. I've practiced labor and employment law in various Texas cities for 30 years. And in that time, I have encountered antitrust concerns that actually arise for human resource professionals and in-house counsel with regard to labor and employment issues. And this is becoming a more intense concern for business, and we're going to talk about why today. I'm joined today by Dan Hemli, who is an antitrust specialist in our New York office and has been practicing antitrust law and has been a specialist in that area for at least 17 years. And I do want to note we are in our New York office today, and there might be an unavoidable announcement over our speaker system about a fire drill. But if that occurs, it'll be very brief, 20 seconds or so, and we'll just pause momentarily for those few seconds until it stops. Also, we're going to go about 60 minutes today. Our plan is to talk for approximately 55 minutes or so, and then have a few minutes for questions. You can put questions in the box that you see on your screen, as many of you have experienced before. If we're not able to get to a question today, I promise you that either Dan or I, or both of us, will call or email you on our nickel and answer your question for you. And that may very well happen today. So with that said, let me explain a little bit about why we're talking about this issue today. Traditionally, antitrust concerns have not been a significant issue in labor markets, at least not a common subject of concern. At FTC hearings that occurred just 4 weeks ago, certain experts in academia and law testified addressing these issues and why antitrust concerns in labor markets, including no poaching and wage fixing agreements, have become a significant concern. A professor from the University of Chicago, Eric Posner, commented that the contrast between labor markets and product markets, and the obvious contrast between the amount of attention that product markets have gotten from the FTC and the DOJ, is significant, and that there's been, quote, little attention to labor markets historically. That's changed. And why is it changing? Well, another speaker at those hearings, Professor Alan Krieger, a professor at Princeton University, a labor economist who's addressed these issues in great detail, and is one of the reasons there's been so much attention. His efforts to bring light to these concerns, commented that the primary reason we're seeing more focus on this issue is, quote, relatively weak wage growth despite a 50-year low unemployment rate. He explained that average wage growth is weaker than one would expect from, quote, historical relationships between wage growth and the unemployment rate. And he noted that although nominal wage growth has creeped up over the last 12 months, nominal wage growth has barely kept up with inflation. And what is interesting is that this, and Dan will comment on this, this has gotten the attention of both parties, including the president, and they're concerned about low wage growth, and they're concerned about what business might be doing to cause that significant wage growth. One issue that we'll just touch on today is non-competes, and to what extent they may be impairing wage growth. But our primary concern is with multi-employer arrangements, whether they be no poaching or wage fixing arrangements, which affect wage growth and which are, as Dan will explain, unlawful. With that said, let me turn things over to Dan to give you the basics about the law and recent developments on this topic.
Thanks, Bob. Good morning. So, as Bob mentioned, my name is Dan Hemli. I'm an antitrust partner in Bracewell's New York office. I focus entirely on antitrust-related matters. And today I'm going to start off just by going very quickly through the relevant legal framework in the US as it is relevant to these topics with regard to hiring and compensation issues. The starting point is Section 1 of the Sherman Act and equivalent state antitrust laws, which prohibits contracts, combinations, or conspiracies that unreasonably restrain trade. That's the legal terminology. That is the main anti-collusion provision under our federal antitrust laws. And so that refers to any sort of agreement or understanding between two or more actors that is harmful to competition. Of course, agreements don't have to be formal or in writing. In fact, often unlawful agreements under the antitrust laws are not written. And whenever, as an antitrust lawyer, we have to evaluate some kind of agreement or arrangement between two or more parties, usually one of the first things we do is that we classify that agreement into one of two categories or buckets. And that is either as per se illegal or under what we call the antitrust rule of reason. Per se illegal agreements are the ones that are most harmful to competition. And for that reason, if two or more parties enter into an arrangement or an agreement that is viewed as per se illegal under the antitrust laws, it then does not matter whether those parties had some alleged, legitimate business rationale for entering into that arrangement. It does not matter if the parties, the companies in question, or individuals in question have small shares of their relevant markets, even if they're small players, big players, none of that matters. And in fact, because per se illegal agreements are so inherently bad for competition in the marketplace, they are often charged by the U.S. Department of Justice as a criminal offense. Now, there are only 4 or 5 categories of agreement that fall into the per se category, and a couple of those are particularly relevant in the HR context, and so I'm going to be getting into more detail on those in a moment. Every other type of arrangement that is not per se illegal is automatically kicked over into the other category, which is what we call the rule of reason category. And that is basically a big gray zone. And there it becomes a very fact-specific analysis in each case where you look at what are the potential harms to competition from the arrangement, and you balance those or weigh those against any legitimate business justifications that the parties may have had for those restrictions, and any pro-competitive benefits or efficiencies that could result from the arrangement. And as a practical matter, when we're advising clients, that is really where you want to be, because even though it is a gray zone, and even though it doesn't mean that your arrangement is automatically lawful, as a practical matter, your risk exposure under the antitrust laws is a lot lower, because it is much more difficult for plaintiffs, whether it's government or private plaintiffs, to prove a rule of reason violation. So let's turn back, though, to the per se illegal arrangements, because those are the ones that are going to be most relevant for what we're going to talk about today. And I've listed there on slide 4, which hopefully you can see, the 4 or 5 categories of per se illegal agreement. There are 4 sub-bullets there, but some people consider market and customer allocation to be 2 separate categories, so you can call it 4 or 5. And I've underlined the first 2 sub-bullets there, and that's because those are the ones that are most relevant in the hiring and compensation context. So price fixing is an agreement between 2 or more competitors and to fix prices. And historically, when most people think of price fixing, they think of, 2 companies that sell the same widgets get together, and their executives, for example, senior executives or salespeople get together and agree on the price that they will charge customers for those widgets. But price fixing can also apply in the HR context, and in particular, it includes wage fixing agreements and other agreements between companies to fix terms or elements of compensation for their employees. And we'll talk more about that a little later on. The other category that I've underlined there is market or customer allocation, which, as the name suggests, that's an agreement between companies, normally competitors, to divide up markets or customers between them. And again, historically, what that would refer to would be, for example, where two competitors that sell widgets would agree, hey, we'll only sell to a certain type of category of customer if you agree not to sell to them, and vice versa, or we'll focus our sales in one part of the country if you focus on a different part of the country. But in the HR context, non-competes and no poaching arrangements, which I'm going to talk about shortly, are also now being treated as examples of unlawful market allocation agreements that are treated as per se illegal under the antitrust laws. Now, I mentioned on the previous slide that per se illegal agreements are often charged criminally by the U.S. Department of Justice. In fact, they are often charged as a felony, and they have very significant consequences for both companies and individuals. So companies can be fined up to $100 million per violation. Individuals can be fined up to $1 million per violation, and individuals can also get jail time up to 10 years of prison time, again, per violation. But the other point, and if that's not scary enough, the other point is it's not just about the government enforcers. And we are going to talk a lot about government enforcement, both at the federal and state levels. But something else that you're going to see kind of running through all of this discussion about non-competes and no poaching and wage fixing is private lawsuits. This whole area has become fertile ground for private class action lawsuits. And under the antitrust laws, and this is a somewhat unique feature of our antitrust laws here in the United States, under the statute, if a private plaintiff can prove an antitrust violation and can also prove that they have suffered injury or damage as a result of that violation, those damages are automatically trebled under the antitrust laws. And that was inserted when the statute was drafted because it was inserted as to have a deterrent effect. So with that, I'm going to turn now more specifically to non-compete and no poaching agreements, and I'm going to start with non-competes. So under our antitrust laws in the U.S., a non-compete is an agreement between competitors not to compete in the same business or for the same customers. And the starting point under our antitrust laws is that non-competes are treated as per se illegal, which should make intuitive sense because the antitrust laws are all about ensuring an open competitive marketplace. And when two companies or individuals get together and decide not to compete with each other, well, that is exactly antithetical to what the antitrust laws are all about. So now, there are exceptions. And for those of you who are in the HR or recruiting world, or perhaps if you do a lot of M&A related work, you're probably thinking, well, hold on, I see non-competes all the time. And that's true, because we do see covenants not to compete very commonly in a couple of areas. One is in employment contracts, which is something that Bob deals with on a daily basis. Another context where we often see non-competes are in contracts for the sale of a company or a business, so in merger and acquisition agreements. And the reason we see those is because under federal antitrust law, non-competes are usually lawful. They are usually okay if they are ancillary to a broader legitimate business purpose, and as long as they are reasonably limited in scope to protect the recipient's legitimate interests. So, for example, we see that a lot in the M&A context. We may talk a bit more about that later on. But when we talk about reasonable, what we mean, and this really becomes, again, a fact-specific question, is if the non-compete is reasonable in terms of the types of activities that are restricted, the geographic area that is covered by the non-compete, and the duration of the non-compete. And that may vary depending on the nature of the parties involved and depending on the nature of the industry. The other important point to understand about non-competes, though, and this is sort of another important theme or takeaway for today, is it's not just about the feds. It's not just about the federal government enforcement. You also have to remember the states. And this is an example of that. And so there are some states, and California is a good example, that prohibit or at least restrict the use of non-competes in the employment contract situation. So Bob, I'd be curious to hear, when you're advising companies that have, national or regional operations, as a practical matter, in your experience, how do they go about navigating the fact that that different states, some states impose different prohibitions or restrictions on the use of non-competes in employment contracts?
Well, Dan, at the executive level, there may be a unique approach taken because obviously non-competes in the context of executive management is particularly important. More broad-based use of non-competes for national companies is a real problem because of the patchwork of prohibitions and restrictions in the various states. For example, California, as many of you may know, essentially prohibits non-competes in the employment context, as does Oklahoma, as does North Dakota, and then a variety of other states have substantial restrictions, such as Colorado, Montana, and now Massachusetts. And then there are a variety of states with very unique requirements, like listing the parishes affected with a non-compete in Louisiana. So it's very, very difficult. And some of you may think, well, we'll use non-competes nationally, and if they're unenforceable in some states, they're unenforceable. The problem with that approach, companies have found, is that in some states, not only are non-competes or non-solicitation provisions unenforceable, they can be unlawful, such as in California. And by trying to maintain an unenforceable non-compete, for example, in California, you can subject your company to lawsuits and damages. Therefore, for broad-based companies operating across the country, uniform or broad use of non-competes is a real problem. On a regional basis, on a state-by-state basis, they can be more common. I will note, before I turn things back to Dan, that there is a move afoot, both in Congress and in various state legislatures, to further regulate non-competes. There is a concern, as we're discussing today, that non-competes, which become very broadly used in some states, like my home state of Texas, are suppressing wages in real terms. And Congress, senators such as Cory Booker and Elizabeth Warren of Massachusetts are very concerned about this. Until there's a change, and of course in the administration, it's unlikely they'll be able to enact those restrictions, but they would like to, through a law called the Employee Opportunity Act, prohibit all non-competes nationally unless the employer can establish by preponderance of the evidence that the anti-competitive effect of those restrictions is outweighed by the pro-competitive value of those restrictions. That's unlikely to happen, but more importantly, more states are moving to restrict non-competes because, again, of the perceived anti-competitive effect they have. With that said, let me turn back to Dan to talk about no poaching agreements.
Thanks, Bob. So that's non-competes in a nutshell. As you can tell, it's not quite as simple an area as we may think, and it may be getting more complex now because, as Bob mentioned, more and more states seem to be deviating from the kind of historical federal approach towards non-competes, and there also seems to be increasing resistance, at least among some Democrats at the federal level. So switching gears now to no poaching. Now, this is an area that has probably generated the most buzz out of all of these types of HR-related antitrust issues in the past, 12 to 18 months. So what is a no poaching agreement? And for those of you who are in the kind of HR type space, you probably already know this. A no poaching agreement is where two or more companies agree not to solicit or hire each other's employees. Now, an important point to understand here, and this is on near the top of slide 7 of our slides, and this is really important. It does not matter if the companies involved actually sell the same products or services. So, in antitrust, typically the worst kinds of agreements, I mentioned this before when I was talking about price fixing or market allocation, are agreements between competitors, companies that sell the same widgets, the same products, or offer the same services. But here, in this context, when we're talking about non-competes and certainly also no poaching agreements, you could theoretically have two companies that actually don't compete in the same product market. They don't sell the same type of widget, but they do still compete to try and attract and hire the same types of employees, the same types of talent, whether it may be, for example, certain types of engineers, or what have you, or certain salespeople. And if those companies, even though they may not be competing in the same kind of product market, if they enter into a no poaching agreement, that is still going to be treated as per se illegal under the antitrust law. Now, historically, prior to 2016, all cases that involved no poaching agreements ended in civil settlements, which basically just prevented the companies from continuing that unlawful conduct. And probably the two most famous cases in that area were the Adobe Systems and Lucasfilm cases, which were both in 2010. So in those cases, the Department of Justice challenged no poaching agreements that were entered into by a number of high-tech companies, including some very well-known names like Google and Apple. And those were challenged as per se violations of Section 1 of the Sherman Act. And what the DOJ alleged was that the companies had agreed that they wouldn't cold call each other's employees. And in the Lucasfilm case, the companies had also agreed that they would notify each other when they were making an offer to an employee of the other company, and that they wouldn't counteroffer above the other company's initial offer. So the DOJ, when they got wind of that, they were not happy about it, and they did bring an enforcement action. And again, it resulted in a civil settlement. But of course, not long after the DOJ announced their enforcement action, you had private class actions filed on behalf of affected employees, and those ultimately resulted in combined settlements of around $435 million. So again, just another example where, at least historically, if anything, the fear of private class action probably was as much or greater a threat in some ways than the government enforcement, which typically just resulted in the companies getting a slap on the wrist and agreeing that they wouldn't continue that conduct. But there was a sign that may start to change, and that sign came in October of 2016, when the DOJ and the Federal Trade Commission, the FTC, jointly published what they called their antitrust guidance for human resource professionals, which was published with the goal of helping employers avoid potential antitrust violations. And the guidance says, a bunch of things, but probably the key points are, first of all, that what the agencies refer to as naked no poaching or wage fixing agreements are per se illegal under federal antitrust law. So what do we mean by a naked agreement? So in this context, and this is quoting from the guidelines, a naked agreement means an agreement that is separate from or not reasonably necessary to a larger legitimate collaboration between the employers, and they give an example of a legitimate joint venture. And so the point there is, if two employers or more than two reach a no poaching agreement or a wage fixing agreement, and we'll talk a little bit more about wage fixing in a little while, unless that is just a small part of some larger legitimate collaboration, such as a joint venture, it will be treated as per se illegal under the antitrust laws. Now, arguably, that wasn't really anything new, because even in the prior cases, the antitrust agencies had treated wage fixing and no poaching as per se illegal. But what was new was the next part, which is the last bullet on slide 8, which is that the guidance then went on to state that the DOJ will bring criminal charges against companies and individuals who participate in naked no poaching or wage fixing agreements. Now, that did generate some buzz at the time, but nothing happened immediately after the HR guidelines were issued by the DOJ and the FTC. And in fact, and that all, of course, happened during the prior administration, the Obama administration, but nothing further happened until January of this year. And of course, then we had a new administration. And on January 19th of 2018, the new head of DOJ's Antitrust Division, Assistant Attorney General Macon Delrahim, who was appointed by President Donald Trump, announced in a speech that DOJ is preparing the first criminal cases involving no poaching agreements. And that got a lot of attention. And so he said that the DOJ would treat naked no poaching agreements as criminal if the activity commenced or continued after the HR antitrust guidance was issued in October 2016. So basically, the position DOJ has taken is that since October of 2016, everyone has been put on notice that if you are involved in a wage fixing or no poaching agreement, a naked wage fixing or no poaching agreement, you're going to be charged criminally. And he identified engineers and other technical professionals as just some examples of the types of employees that they are seeing who might be the subjects of illegal no poaching arrangements. And then he said that he's been shocked about how many of these there are, but they are real. So that was in January of this year. It generated a lot of attention. That speech by Delrahim generated a lot of attention. And we didn't have to wait very long until the DOJ brought an actual enforcement action, and they did it in April of this year. Although, interestingly, it was a civil lawsuit. So on April 3rd, the DOJ filed a civil lawsuit against two of the world's largest rail equipment suppliers, Knorr-Bremse and Westinghouse Air Brake Technologies Corporation, or Wabtec. And the DOJ alleged that those companies had a naked no poaching agreement in effect between them from 2009 until 2016. The DOJ also alleged a no poaching agreement between those companies and a third rail equipment supplier, Favorly Transport, a French company, before Favorly was acquired by Wabtec in November of 2016. And that's actually an important point, and we'll see why in a moment. The DOJ alleged that the no poaching agreements here covered skilled U.S. rail industry employees, including, interestingly, employees in a number of different functions, project managers, engineers, sales executives, and corporate officers. So it sounds like it was pretty widespread. At the same time that the DOJ brought filed the lawsuit, they filed a settlement that prohibited the companies from entering or maintaining such no poaching agreements and requiring the companies to implement various notification and compliance measures. And then, of course, shortly after the DOJ's announcement, private plaintiffs filed a number of class action lawsuits against those companies on behalf of affected workers, and those lawsuits are still pending. Now, this is an interesting case for a number of reasons. First of all, even though the no poaching agreements were charged again as per se illegal under the antitrust laws, the DOJ used its prosecutorial discretion and chose to bring a civil action rather than a criminal prosecution. Why? 3 months earlier, Macon Delrahim had made this whole thing about, we're going to go after these things criminally, and now their first enforcement action after he makes that speech is a civil action. Well, it all had to do with timing. It turned out, or at least the way DOJ explains it, is that the DOJ discovered these arrangements and the companies terminated these no poaching arrangements before the HR antitrust guidance was issued in October of 2016. So the timing worked in the company's favor here. Another important takeaway from this case, and frankly for me, as someone who does a lot of merger and acquisition related antitrust work, one of the most interesting aspects was how DOJ actually discovered this no poaching agreement. So it turns out that DOJ detected these no poaching agreements while they were conducting a completely separate and unrelated review of Wabtec's acquisition of Favorly. So, in the merger context, some of you may know, for most merger or acquisition transactions that are above a certain dollar size in the US, you have to notify the federal antitrust agencies, the DOJ and the FTC, and you have to provide various documents and information so that they have an opportunity to review that transaction from a competitive standpoint. And that's what Wabtec and Favorly did. And they were undergoing a, fairly in-depth but, standard or routine merger investigation. In the course of that merger investigation, they produced a large volume of documents, emails, etc., to the DOJ. And it was during that the DOJ found evidence of the no poaching agreements. And by the way, the DOJ ended up clearing the acquisition. I believe they imposed some conditions, but by that stage, they had opened a completely separate investigation into the no poaching agreements. So there are of course, some obvious practical lessons there, which we'll touch on at the end. As part of the settlement, the companies agreed to hire antitrust compliance officers and to report on their compliance annually for the next 7 years. Also, interestingly, this is for the settlement is not only what the settlement does prohibit, but also what it doesn't prohibit. So it does not prohibit the companies from entering no poaching agreements that are ancillary to a legitimate business collaboration, and that's consistent with what the HR antitrust guidance says, provided those agreements are narrowly tailored. I don't know what narrowly tailored means, but I take that as being kind of equivalent to the reasonableness concept. And secondly, the settlement does not prohibit the companies from unilaterally adopting a policy not to solicit or hire someone else's employees. And that actually is an example of an important general concept in antitrust, which is that companies generally have a lot more flexibility under the antitrust laws with regard to their unilateral business decisions and business behavior as compared to or as opposed to collective behavior involving other companies.
Dan, as part of my labor and employment practice, This is Bob Nichols. I assist employers with labor issues associated with M&A work, as well as joint venture work, and of course, contracting work such as master services agreements. And in doing that labor and employment work, I frequently see non-compete, non-solicitation provisions in those agreements. Those are between two businesses. So could you help us understand when those type provisions and those type of agreements are lawful versus unlawful?
Sure. And yes, we do see those a lot. And so, and it kind of goes back to something that was on an earlier slide. It goes back to this whole concept of if you have a non-compete or a no poach, no hire, or certainly non-solicitation provision that is ancillary to a broader transaction or arrangement and is reasonable in scope, then you're usually okay. So the first point is that in that context, those types of non-competes or no poaching provisions are analyzed. Those are not usually treated as per se illegal. Those are analyzed under the antitrust rule of reason. So now, if you remember, that means you're now in this big gray zone where everything is a little bit more murky. But as a practical matter, that's a good thing. That's where you want to be. And then it really becomes a very fact-specific question. So if I'm looking at and we see this a lot in merger agreements or purchase agreements, if we're looking at an asset purchase agreement or a stock purchase agreement, and we see a non-compete provision and maybe also a non-solicit, we'll look at the duration, we'll look at the geographic coverage, we'll look at the activities prohibited. And if those seem reasonable in the context of what the companies do and in the context of the industry, for example, is it a very capital intensive business where it takes a lot of money and time to enter? In those kinds of situations, a longer non-compete and non-solicit may be more justified. So that's something we look at often. I would say, nine times out of 10, we look at those and we can quickly get comfortable that they're okay. Joint ventures, again, similar thing. If you have a legitimate joint venture arrangement and the two joint venture partners agree that they won't compete with the joint venture while the joint venture is in existence. Again, as long as that all seems legitimate, as long as the scope does not go beyond what the joint venture is intended to do, usually we can fairly quickly get comfortable that that's okay. And then in the like master services agreement type of a situation, or if you have like a contractor customer type of relationship, again, it all comes down to, is there a legitimate business justification? And so in that case, I could certainly see where let's say a contractor who is placing their employees, their people at a customer for a period of time should have a legitimate interest in protecting its investment in those people and preventing, at least for a certain period of time, the customer from poaching those people away. So yes, we see those a lot, and generally speaking, as long as there's a real genuine business rationale, and as long as the scope of the non-compete or non-solicit, is not anything overly broad, you're probably fine. One other side point I'd mention there, just before we move on, though, is for example, in the M&A context, usually those types of non-competes or no solicits should only flow in one direction. Meaning, usually it is a non-compete and a non-solicit on the seller to protect what the buyer is buying. And so the buyer of a business wants protection. They want to make sure that after the day after they close on their purchase, the seller can't just set up shop across the street and hire back all of the same people. But usually there is no justification for a non-compete or non-solicit on the buyer. There might be unusual circumstances, but that's generally the case. Joint ventures are a little different. In a joint venture, it's much more common to see a mutual non-compete. So that can vary a little bit depending on the particular situation. One other topic I want to very briefly mention on no poaching before we move on is the franchise sector. And this is another somewhat hot and developing area, and it's really just an extension of the no poaching concept. So it really all started last year when two Princeton University economists published a paper analyzing no poaching clauses in franchise contracts that restrict recruitment and hiring of employees from other units within the same franchise chain. And they found that 58% of major franchise chains, including fast food restaurant chains like McDonald's and Burger King, include no poaching clauses in their franchise contracts. And they concluded that these restrictions reduce workers' job opportunities, they reduce mobility of workers within the franchise chain, and may suppress wages. Well, that got the attention of state attorneys general. And interestingly, it has been the Washington State Attorney General, and that's not the District of Columbia, that's not DC, that's the state of Washington in the Pacific Northwest, who has really taken the lead on this issue. Bob Ferguson, the state AG in Washington, opened an investigation earlier this year. As of last count, his office has announced settlements with 30 companies, 30 corporations, including 23 fast food chains, including some very well-known fast food chains that we all know and love, and 7 other corporations, all of whom have agreed to stop using no poaching clauses across all of their franchise locations nationwide. So we're talking about, impacting tens of thousands of franchise locations around the country. Interestingly, in October, the Washington AG's office sued one restaurant chain after it refused to remove no poaching clauses from its franchise contract. So it'll be interesting to see how that unfolds. And in the meantime, another group of 11 state attorneys general is conducting their own separate investigation into no poaching agreements within the restaurant industry more broadly, not just limited to the fast food industry, although as you can see, even the Washington AG's investigation now has broadened beyond just the fast food sector. Now, this may or may not sound of interest, but what I would tell you is, there is really no reason to think that this heightened focus on no poaching clauses is going to stop with the franchise space. This may well be the tip of the iceberg for all of the reasons that Bob alluded to in his introductory remarks about concerns around sort of tepid wage growth. But this is certainly an area that has generated a lot of buzz recently. All right, so now, pausing for a moment, we're going to switch gears a little bit and talk about another area that implicates the antitrust laws, and that involves wage fixing and exchange of employee compensation information. So, an agreement between competing employers to fix employee salary, wages, or other elements of compensation, whether at a specific level or within a range, is going to usually be treated as per se illegal price fixing. That's wage fixing. And an important point there is it doesn't have to be just an agreement to fix wages or salaries. If companies agree to fix other aspects of their compensation, like benefits or things like that, that is still per se illegal price fixing under the antitrust laws. But the other point to understand there is, even if there's not enough evidence to prove an explicit agreement to fix salaries or wages, even the mere exchange of compensation information can violate antitrust laws under a rule of reason analysis, if it causes anti-competitive harm. And so we have a couple of fairly recent cases to illustrate these points. The first, and we're on slide 15 here, is FTC versus Your Therapy Source, LLC. This is a case from earlier this year, 2018, in which the FTC and the Texas Attorney General, so again we have state involvement, not just federal, alleged that two therapist staffing companies and their owners agreed to reduce pay rates for therapists and that they invited other competitors to collude on rates. So these are companies, small companies in Texas that hire different types of therapists, like physical therapists, etc., and they hire those therapists out to other companies. And this was an attempt to prevent therapists from switching between staffing companies who were offering higher rates. The defendants settled with the FTC in July of 2018, so about 5 months ago. This was the FTC's first enforcement action since the 2016 HR antitrust guidance was issued. A few notable aspects of this case. The first, something that I thought was really interesting, the agreement here, the wage fix, this was a typical wage fixing case, okay? But what made it interesting? A couple things. First of all, the agreement was all done via text message. In fact, the FTC's complaint quotes from some of the text messages that were exchanged between the owners and executives of these companies. So that really just goes to show that, you know, the antitrust laws can fit with the times and can apply irrespective of the technology used. Also, the fact that the companies in question were relatively small, privately held companies, these were not big multinational corporations, that didn't matter. That, you know, the FTC and the Texas AG still went to the time and effort and put the resources in to investigate and challenge the conduct. And the settlement here prohibits future agreements on compensation and exchanges of compensation information. The other case I want to briefly mention is the case, the Miranda case from a couple of years ago. This one actually was not a government case. This one's interesting because it was a private class action lawsuit brought against 8 hospitals in the Detroit area, alleging that they conspired to hold down the wages of registered nurses and that they exchanged compensation-related information in a way that reduced competition in the wages that they paid RNs. And what was interesting about this case was a couple things. First of all, the defendants allegedly exchanged compensation information in multiple ways, some through direct interactions, but some through third parties by participating in surveys or in trade associations. And the district court, on a summary judgment motion, after looking at all the facts, the district court granted summary judgment to the hospitals on the per se claim. So it found that there wasn't a per se illegal violation, but it found that there was enough evidence from the various exchanges of compensation information to deny summary judgment under a rule of reason analysis. So this is a recent example of a case where even exchanging compensation information, even if there's no explicit agreement about compensation, may be enough for an antitrust violation under the rule of reason. The case was settled in 2016, total compensation from all defendants of $90 million. And finally, before we go over a few practical pointers, compensation surveys. So in the mid-1990s, in the healthcare area, the DOJ and the FTC created what they called an antitrust safety zone for employers who participated in surveys of wages, salaries, or benefits, as long as those surveys met certain criteria around having a minimum number of participants, making sure the information was a little bit dated, a few months old, and making sure that it was aggregated in a way so that the survey participants couldn't figure out each other company's individual, wage or compensation information. Now, the safety zone was originally specific to the healthcare industry, but it really became a useful guide for other industries as well. And even though it's a little dated now because it was issued in the 1990s, companies still and councils still look at those guidelines. But in June of this year, 2 U.S. senators, and it actually happens to be the 2 senators that Bob mentioned earlier, Cory Booker and Elizabeth Warren, both Democrats, urged the antitrust agencies to rethink or update this antitrust safety zone. We may not see very much come of that in the current administration, but depending on what happens in the White House in a couple of years' time, given the growing interest in this area generally, it wouldn't surprise me if we see more on this topic. So with that, to kind of finish things off, and then hopefully we'll have a few minutes left over for questions, we thought it would be useful to kind of bring all of this together and provide some practical tips. And this is obviously high level. You know, each situation needs to be evaluated on its own circumstances, but a few general guidelines to think about in this area. And the first is that companies should really review their existing contracts for any non-compete or no poaching provisions and consult with counsel about whether it makes sense to either remove or maybe modify those provisions. Just to be clear, I'm not suggesting that you can never have a non-compete or a no-poach provision in a contract. As Bob and I have talked about in some detail, there can be a number of different situations where those are perfectly legitimate. But given the heightened focus on these now, it's probably not a bad idea for companies to review their existing contracts and just make sure that if they do have any of these, that they are okay. Similarly, it's probably prudent to seek legal advice before you include these types of non-competes or no poaching provisions in future business arrangements. Also, be careful about not just non-competes and no poaching, but exchanging employee compensation information with other companies. And by the way, that's true not just on a one-on-one basis, but as the case in Miranda case shows, you know, trade association meetings, social gatherings. I mean, these are all, you know, prime opportunities for companies, even inadvertently, even if no one has any bad intentions, to exchange HR-related information that they really should not be exchanging. So something to be mindful of. And, you know, companies shouldn't communicate their compensation and hiring policies to others who compete for similar employees. Bob, do you want to cover the rest?
Absolutely. As Dan has taught me, it's important for you to educate not only your executive management, but your supervisors and management generally about these principles. Why? Well, as we've talked about, these agreements normally are not formal agreements that have been vetted by the legal department. These are deals struck, and sometimes struck at the mid-level management level. And I will caution you, for example, if you have mid-level managers in Midland, Texas, responsible for the Permian Basin, and they are trying to deal with the shortage of engineers or technicians or drillers, and they have a lunch with their colleague at another company locally, and they agree not to go after each other's engineers or technicians or drillers, they almost certainly have formed a naked and unlawful no poaching agreement. So you cannot rely on the fact that you understand these principles. You must train your workforce, all your supervisors and managers on these principles so they don't cross the line. After all, emails, text messages, lunches, trade association meetings are often where these unlawful, sometimes tacit, sometimes implicit arrangements are struck. So do training. Also, next point, train your HR staff and your senior management on the DOJ FTC HR guidance. As Dan indicated, the DOJ has made it clear that they regard HR professionals or management who disregard the issuance of that guidance, now that it's out, as a major consideration in whether to pursue criminal sanctions. So your HR professionals and your senior management have to understand the very practical guidance provided for in that DOJ FTC document. Remember, of course, that during unrelated events such as M&A work, including DOJ review of a merger, these issues can come up. So this should be an issue you pay attention to during due diligence in transactions. And you should also realize, as Dan's pointed out, that if the DOJ is going to look at one of your transactions for antitrust compliance, they may very well look at this issue in particular now. If potentially unlawful conduct is identified, consult with counsel to evaluate potential exposure and discuss next steps. You simply shouldn't disregard the discovery of a problem. Your counsel may have thoughts on how to remedy or address non-compliance that exists in your company. With that said, I think we're finished, and I very much appreciate your time. Let's talk about questions. One question that has come up that I want to pose this to Dan is there ever a situation where a company may want to self-report an unlawful or potentially unlawful arrangement like we've discussed today that they discover within the company?
Sure, thanks, Bob. So the answer is yes, they may want to. The question, and we often get this question is, and thank you for submitting this question, because it's a good one, is, do you have some sort of obligation to self-report? And the answer to that, at least from under the antitrust laws, is no. There is no legal obligation to self-report or disclose a potential violation, but the question becomes whether you should do so. And the answer is it depends. And so first, you need to figure out if there has actually been unlawful conduct that violates U.S. antitrust law, or for that matter, some other jurisdiction's antitrust law. And then you need to think about, just as a practical matter, how likely is it that the antitrust authorities, whether it's federal or state, will ever find out about the conduct. So, for example, as we've mentioned, if you're preparing for a merger that is likely to get a detailed antitrust review, that's certainly one way, as happened in the railway equipment case, that the agencies could discover the arrangement. Or it's also possible that one of the other companies involved in the conduct might decide that they want to voluntarily self-report to the authorities, and that's something you need to take into account. Now, in the U.S., one other very important consideration when you're thinking about possible self-reporting is to remember that the DOJ has a leniency program, which has been very successful for them, whereby the first company in the door that reports a criminal antitrust violation, if they meet certain criteria regarding, full and complete cooperation, etc., they can receive complete immunity from criminal prosecution. So that has been a very powerful tool by DOJ to get companies to self-report. Now, last thing I'd mention, because I think we're just about out of time, but on this topic, even if you decide not to self-report the conduct, at a minimum, companies in that situation who have discovered evidence of a potential antitrust issue should immediately take steps to stop participating in the conduct, whether it's a naked no poaching agreement or wage fixing, and they should talk to counsel about what other steps perhaps should be taken. For example, maybe terminating or disciplining the individual employees involved, maybe providing some additional antitrust training for relevant personnel, etc.
Well, thank you, Dan, and I hope you all enjoyed our presentation today. I do want to note that a couple of my colleagues, Jim Kazar in our San Antonio office and Chris James in our Dallas office, are going to be presenting a employment disability law update on Thursday, December 6th, and I think you all would find that valuable. Anyway, thank you for joining us today. This is an important topic that we addressed, and it's only going to become more important with the increasing focus at both the federal and state level. Thank you again, and have a great day.